Hello, everyone. Harry here to talk about the Alex Murdaugh trial and the defendant's decision to take the stand. And I'm really happy to be joined by Danny Cevallos, who is A, my good friend, B, really has great trial chops and experience, and C, has been following the trial. So, Danny, thanks a lot for being here.
Thank you so much for having me. And I am proud to be, I must be one of the first defense attorneys in what is probably a series of former federal prosecutors.
It's really
so I am
true.
truly honored to finally balance this out
Right.
because I have no doubt this has been a very pro-prosecution leaning show.
You know, it's really true. And I'm trying to think about even the quote unquote defense attorneys. I think you might suggest, well, like Barry Burke's been on, or Norm Eisen styles himself a defense attorney, but you're the real
Sure.
deal. I mean, and it's a special and important mindset. As a prosecutor, I often felt envious of colleagues or a few who got to be friends in the defense bar because, the defendant, to me, as to the jury, as to the world, was this distant figure that you really didn't have the personality down for. And I got regaled with stories by defense attorneys of like some good, some bad, but crazy stuff that was part of their relationship, with a very human relationship with the defendant. More about that later. In fact, maybe we should have a Talking Feds podcast on defense attorneys in general. It seems like equal time. But let's cut to this chase, because the end of last week was, the big high drama moment in a defense attorney's life. Alex Murdaugh, charged with sensational murders of his son and wife, took the stand in his own defense, which we know to be, maybe we'll get into this, a rare decision. So let me ask you that. You probably have a better vantage point. What's your take on the calculation that led him to decide to testify in his own defense?
There's an unwritten rule that defense attorneys never call their client to the stand unless there is a piece of evidence, a piece of information that they need, and they simply can't get it anywhere else but from the mouth of the defendant. And yet, I don't think that test was met with Murdoch taking the stand, which leads me to believe that, as we all know, a defendant has a constitutional right to either testify or not testify, that maybe he had done so against medical advice, as they say, against the advice of his attorneys. And it was telling when the attorney said, Mr. Murdoch would like to take the stand in court. I wonder if there was something to be read into that. So using the rule that never call your client unless you absolutely need something from him, not only do I not think Murdoch offered any new fact that wasn't already known. So for example, some might say, well, the jury wants to hear him get up and deny these crimes. Well, maybe, but they've already heard that. He's spoken on videos, on body cam videos. I mean, the bottom line is he's already denied these crimes. But what he did do is apparently hurt himself. Now, the theory may be, I got to get up there and explain all this OnStart technological data and evidence. But his explanation was essentially, yeah, I'm not denying that anymore. It was me that lied. The data didn't lie. I was the liar. That's not an explanation. And yet, Harry, I got to tell you, as much as a disaster as I think his testimony has been, I've talked to people, and maybe you have too, that think he still has a fighting chance, and he may for that reason. And it just astonishes me, Harry, because I got to tell you, I've had so many cases, often with some nobody, non-famous defendant who isn't influential, high crime neighborhood, disadvantaged neighborhood. They get convicted on these facts. I mean, let's take a step back. You see these facts, and it's not Alex Murdaugh. And the facts are, and they appear to be undisputed so far, that he was there. He was there minutes before the killing, and he lied about it. He had access to a firearm, and he's a drug addict, a serious drug addict who may have been going through withdrawal. I think, Harry, you'd agree. In another case, this is a guilty verdict.
Okay, and so I want to go through in some fine detail some of the back and forth, but at the point of decision, well, first let me one quick follow up in brief, in a few sentences, why is this the unwritten rule? Because you're certainly right. And I think lay people are not generally aware of it. They're sitting there, or a jury sitting there, and they think we really want to hear from him. And if we don't hear from him, and defense attorneys know, of course you do, but we're not doing it unless the Danny Cevallos rule is met. Why is that the rule?
Because defendants often mistakenly think of this as a fair battle between prosecutor and defendant. And it's not. The prosecutor's not testifying. The rules are slanted against the defendant. You can argue with the prosecutor, but it's your testimony that matters. And the problem with Murdoch is he's someone who probably thinks he can talk his way out of anything.
Yeah,
After all, it
I
seems
just
like
because I want to double back to Murdoch too. So it's just that, and also it's often the case. There are things that will come out on cross-examination as ostensibly relating to defendant's credibility that
right.
are really taken as substantive evidence of guilt. I had a defendant in a financial trial decide to testify, and he did have a little criminal conviction for murder for hire. And when that came out of it, you could just hear the gasp from the jury, and his ability thereafter to get a fair shake had to be in real doubt. I want to so first, I totally agree, and moreover, I felt you would have a better sense of this, a strange absence of rapport between defense attorney and the defendant. When he was testifying on direct, he served up these obvious questions: did you kill, did you not? But he the defense attorney, seemed somewhat distant, and I wondered if that reflected your point about against medical advice. But as I tried to think about it more, it seemed stupid in the abstract, it seems stupider in the concrete. However, here's a guy who for 20 months lies about whether he's, in the kennels, and he doesn't know. They recover late in the day the video from his son, which by the time it's time to take the stand, shows him there. If they had that piece of evidence before, the trial would have been different. But at this point, the whole defense has been a lie, and the one fact it's hardly evidence that he has to do is somehow try to explain that away. I wonder if that was part of it. And I wanted to ask you this as part of your experience as a defense attorney. First, does that strike you that be as so damaging that he thought he had to take the stand? And second, the trial, everyone in the jury found out after the trial was well underway. Is that something you think the defense attorney knew or didn't know, that he was lying all the time about being at the kennel?
Well, it wouldn't be the first time that a client misled his attorney. It's happened to me. It happens to everyone. I wouldn't be surprised. Maybe it wasn't the day before. What if it was mid-trial? That creates a lot of thorny issues for a defense attorney. So I'm not entirely sure, but I'll tell you the way I might approach that. If my client lied to me right up until trial,
Or just
unfortunately,
withheld. I'm just positing he withheld. He never.
or withheld, or withheld this important information. If my client had done that to me, I might be inclined to say, all right, well, you know what? You've made your bed. Go ahead and take the stand. You've burned us. Now we're in a terrible position, and you're going to get up and explain a piece of evidence that's damaging to us. And your explanation is basically, I lied. That's not really an explanation. And the other problem with calling Murdoch is that you normally don't call your client if they have massive credibility problems. And Murdoch did. So again, that's another point in favor of defense attorneys probably didn't want to call him. And we learned nothing new from him, except he's an even bigger liar than we originally thought. Harry, I couldn't help but think what this reminded me of, and why I think he still might have a shot at acquittal, is something you may be familiar with, is a cooperating witness. In other words, somebody who has massive credibility problems. But as prosecutors often say in their closing, look, it takes a criminal to catch a criminal. Yeah, he's a liar. He's been convicted of lying, but he's here today telling the truth. And that is sort of the needle that it seems like Murdoch is trying to thread. It reminded me of when I cross-examine a cooperating witness. Well, you lied about this, you lied about that, and you were convicted of fraud and all these other things. But you know what I find, Harry? That juries are willing to accept those witnesses, warts and all. In other words, yeah, this is a convicted liar. He's brought into the courthouse in shackles and takes the stand and testifies in his jumpsuit from prison. And yet I find with cooperating witnesses, juries are willing to accept their faults and listen to them and believe them. So that's why I think it's possible Murdoch has a fighting chance. But then I take a step back, Harry, and I go back to, the vast majority of murder trials. And I think on these facts, anyone else would easily be convicted. And I think, if anything, the state made a mistake. And that mistake is, and I understand this mistake, because prosecutors have to prove their case beyond a reasonable doubt. And for that reason, especially in federal court, it feels like overkill. It feels like they're dumping a massive amount of evidence on the defense. And I wonder if these state prosecutors got too ambitious and thought, okay, let's come up with this financial crime evidence and we'll advance a motive. We need a motive. We need a motive. Even though they don't really need a motive, they felt as if they did need to give the jury a motive. And that motive, I think, was a bad one. It's one that juries can't believe. And it's that Murdoch had committed so many financial crimes and his walls were closing in on him that he killed his wife and son to engender sympathy. And I just don't think that's something the jury's going to buy. And what I think the state is going to do in their closing, and I sense they've already been doing this, is they're going to pivot away ever so slightly from that theory and use it as, it could be that, could be anything else. Or they'll just say, look, it doesn't matter what the motive is. He's a drug addict. He was there. He may be crazy. He's going through withdrawal. We don't know what the motive is, but look at the evidence. He's the only guy there. He's got a firearm and he lied about being there. And I think that will go a lot further. And I wouldn't be surprised if they abandon the whole financial motive theory.
Interesting. All right, let me sort of put in a few points as a former prosecutor. In general, so there's a half a day of cross-examination followed by a full day. And I thought, by and large, the commentariat kind of gave blow marks to the prosecution for the cross-examination in the first day for the reasons you're saying, just plotting through all this financial stuff. I disagree, and I'll give you my thought and philosophy here. Basically, anything that you think you're going to use in closing, you need to bring out now. And there are a lot of facts they may need to use, and even if it seemed a little boring, that prosecutor, who struck me as pretty skillful, we'll get to this in a moment, was methodically surfacing facts or points that are then going to come up in the closing. Maybe you're right that he tacks away from it, but I found that I did not agree that it was overkill and certainly not dull. I thought the general watchword of cross-examination, every question a little a bite-sized fact, get him to admit it. Now he's an interesting guy to cross because he's a lawyer and he would sometimes take it on himself to not admit but go into these long-winded,
of course,
biased defenses. But generally, so I thought that was okay. But let's move to Friday, because
can I jump in real quick, Harry? One thing I just want to say, I agree with everything you just said. I agree that they have to question him about every single lie so they can cram that into the closing. I'm 100% with you. I don't care if it's boring. Yeah. They have to hit every point. The only part I disagree with the state is weaving a motive of the financial crime, the financial crimes being why he killed his wife and son. I do agree with you. You need to make a list of every single lie and hit him with it, not just for the jury, but as you said, surface every fact so you can put it in your closing. You never know what the jury's going to seize on. You never know what they're going to seize on. And you hate that feeling of wondering later on, should I have asked, because I've done that. Like I've printed out a 20-page, 50-page cross-examination script, and you shouldn't do that because cross-examination is fluid. And I'll get halfway through it and I'll think, oh my God, I've made this too long. I wrote heavier than I should speak. And I'll sometimes bail on things. And that's a bad idea because later on I'm like, why should I have mentioned this? I should have mentioned this. And so It's a dilemma. But I agree 100% with what you're saying. I'm just not in on the motive. And I don't think they're going to stick with it.
Although, the jurors are sitting. Well, let's get back to that at the end. I also want to make one point that that as from social science that I took to heart as a prosecutor, which is, length matter. The two things that matter are the sort of high points and the end. So that's what jurors take away. So he moved then in for the kill. And I want to follow up on your point about jurors maybe giving Guy a second break. When he's basically saying, look me in the eye, I've been lying all my life, but I'm telling you the truth.
Right.
If they don't believe that part, then, they totally want to crucify him. And here's what I thought the prosecution did very adroitly and skillfully. They threw great doubt on his news story.
Right.
And they did it with really meticulous marshaling of texts and steps. And it's kind of scary to how much we are surveilled out there more than we know. But basically, they got it to a point where he's there until 2 minutes before the son and mother and his mother's, the son and wife's phone are disabled. 2 minutes before, and the whole thing is like, they have him leaving within minutes before they die, meaning that somebody. And of course, it's the almost shades of OJ. We don't know who, but they're the, as the prosecutor put it, unknown vigilantes who just came in those 2 minutes, knowing he wouldn't be there, finding the guy. That made it super incredible. And I think if the jury's sitting there thinking, oh man, I know he lied to everybody, but now he lied to us. That I think could be devastating if they don't, the prosecutor doesn't seal it up in loose sight, but comes very close to making his news story be extremely far-fetched. What did you think?
There was one question, you probably saw it, and often trials come down to this. There was one leading question the prosecution asked, and it was a long one. And normally that might be a risk, but it was really more for the benefit of the jury. And it went something like this. So your theory is that you, in the 2 minutes you weren't there, 3 minutes you weren't there, vigilante, 5 feet tall, makes his way onto the estate.
Yeah.
He knows that your wife and son are at the kennels as opposed to the house. He tracks them down and then he shoots them and he's out of there before you get back. And it was one long question that really, who cares what the answer was? That was the high point, the crescendo of the day's testimony, in my view. And I think you may be thinking of that same question. I thought it was incredibly effective. Who cares what the answer was? The jury heard that cockamamie theory, and they must have digested it.
Hey, everyone. We're taking a quick break to ask you to take a second to like and subscribe. It's a quick thing that really helps the show. Thanks, and back to the video. All right, so now let's go to the X factor, the thing you said. And I find as a prosecutor, maybe you found this as well, it's a little hard to predict, especially if you're not in the jury room. To me, in my, analytic prosecutorial mode, it seemed pretty clear he was lying, and there are some real tells. I thought, and just in general, it's an extremely hard thing. He got emotional at certain points, but then he doesn't, you don't modulate away from it's a very hard thing not to lie in an emotional way and then carry through what seems a consistent kind of comportment for someone who's just been that way. However, the hope is one out of 12 somehow, really feels it in the heart. And maybe you had a real opinion about this. As I said, that to me is often the wild card in the Hail Mary. It seems obvious that someone's lying, but who knows how juries react to those sorts of heartrending stories in real time. So I wanted to ask you about Murdoch in particular. My experience in general, do you find that is a little hard to predict as opposed to specific facts that have been, pushed back against? And how did you think he pulled it off? Let's say we're cynical lawyers, assuming he was lying and he was putting on a performance. What acting grades do you give him?
Right. I mean, I love when folks ask us lawyers, hey, where do you think the jury will go? Lawyers don't know any better. And case in point, if we knew how a jury would go every time, then I would plead my client guilty, or I would go to
Yeah.
trial, and or the prosecutor would drop the case. And that doesn't happen. We go to trial because we have differing views on what a jury will do. And I got to tell you, I don't know if you have this feeling, but when a jury's out, I have no idea. I have stopped trying to read the tea leaves. I have stopped trying to look into their every question. Of course, the client wants to know my take on it. I don't know. And I don't think there's ever been a verdict that I didn't doubt before it came out, or that I wasn't surprised in part about. It's just never happened to me.
All right. In fact, you reach out to a point. I think we should get together again at just this point. I think when a jury goes out, sort of your own psyche takes over. I myself, just like you, part of me is unbelievably relaxed. It's just
Oh,
there's
yes.
nothing I can do but wait. But also, I tend to have, prosecutions, as you've noted, they usually have, they have superior firepower and facts and law, perhaps, and they have a strong leg up, but I often have all of a sudden can talk myself into grave doubts if I don't just, tell myself to shut up right
Yep.
after a trial's gone in. That's a very interesting time for a trial lawyer. So maybe after the closing arguments here, we can reconvene and talk a little bit about where we think it's going.
Can I ask you? I mean, I often
Yeah.
think that for especially federal prosecutors, and I just had a federal jury trial in Pennsylvania, the Eastern District. And I've always
Good.
thought it must be so much scarier for prosecutors because, in a sense, as defense attorneys, look, the government wins 90+% of the time. There's a lot of pressure on you folks to win, and you're going up against a presumption of innocence and a beyond a reasonable doubt standard. And because you have to build your case, the level of work that has to go into organizing that, whereas a defense attorney can sit back and take pot shots, you have to build your case brick by brick. So, I mean, in a way, as agonizing as trial is for me, and I got to tell you, I am in the fetal position in the bathtub, as every night after
Yeah.
trial ends. I wish I was one of those water off a duck's back defense attorneys, the
Right.
guys with the two-tone shirts and the chalk striped suits. They don't care about nothing. And anything can happen during the trial, and they're fine with it. That is not me. I agonize over everything. And I have to think, I often think for federal prosecutors, for who have lived with the case longer than me, if they've been investigating the guy for a while, it's got to be pressure is on, especially when the folks from your unit come to see the verdict and you have a lot more people coming, the FBI agents come in to watch. I mean, it's a lot of pressure.
It's so true. And let me just add to it. First, you don't build your case brick by brick. You got to build the whole city because you don't, there's literally, it's like a chess game. There's almost an infinite number of trials it can be. And you see, and there are giant, it'll maybe go, you are on decision trees. If it goes this way, you got to be ready, or that way. Maybe your instincts can take over, but to really be prepared, there's so much to do. I thought to myself, yeah, I'm a swashbuckling prosecutor. Give me the trials. Give me the trials. And now I'm in trial prep the week before. Like, why did I want
Why?
this trial? I just
Do that.
have a permanent stomach ache, and there's infinite preparation you can do. That's one. Second, you're right. 98% trials, but the big ones tend. I mean, we're seeing this with Clinton, right? You had Pomerantz tell Bragg, 70%. 70%, that's 30% you can lose. The bigger trials aren't 98%. They're more like 75, or
Sure.
so they are really losable, and it is on you. So that I'm sure people are idiosyncratic this way. I certainly had colleagues who I thought, geez, this guy's a real does he have no blood in him? He's just fearless. The guy, Rodney King, I worked on the case, a guy named Steve Clymer, who's still at DOJ. Best I could tell, although he also was always full of doubts. But I think so. It's 100% right, especially on the big cases where you could actually lose. Um, you know, Well, we should have more of these conversations now. I want to come back to the idea of three defense attorneys. But yeah, there are different human beings as prosecutors and defense attorneys, and there's different kinds of pressures. But I especially feel the few days before that the weight of that, because you don't know how the trial is going to go, in contrast to, your colleagues on the other side who are, if they can, get in 3, 4, 5 good shots and, 2 of them hit clean, that could be the trial.
Can I just say real quick
Yeah.
just to tease our segment when we do come back and talk about that, I'll talk about my 2 different kinds of defense attorneys. You may have more. The one is probably like me. I read every stitch of paper and I freak out and I'm panicked. But I love the guy that I talked about in the chalk striped suit with the 2-tone shirt who doesn't even read the file and just comes into court and razzle dazzles, and that guy wins. Sometimes that guy hasn't read anything.
If you're like me, you get you get people call you. It's a funny part of the world. Every, I don't know, twice a year, a friend calls whose son has just been arrested, etc. You need to get him a good defense attorney. Whom do you tend to recommend? Yeah.
Yes,
I
exactly
recommend you, not the 2-tone guy. Danny Cevallos, I always recommend you. Thanks very much for the conversation. And this is going to get, the pretty interesting and rich just this week, right? It looks to me like it may be closing arguments might be Wednesday or so, yeah?
Yes, I think so. I think we're going to get there. I don't know how long the charging conference will take. I mean, I just had one last an entire day, but this is probably a little more straightforward as opposed to a white-collar case.
Here, let me ask you one question. There was, I wonder, are we going to see a rebuttal case? I just wonder about this blood splatter thing. Did you hear this? I mean, I had and I don't think it came earlier, right? There's some suggestion that they're going to have some forensic with splattered blood microscopically on his shirt. What's that about?
Yeah, I'm not so sure either. I mean,
that would be classic rebuttal case, right?
Yes.
It would be. Yeah.
Yes, I think so too. We may see that. And I want, the prosecution, I can see they're trying to cover every single base they can, which is understandable. I mean, they've got to cover everything because you don't know what this jury will seize on. And they probably are aware that these Murdochs somehow have this sway over everybody in this jurisdiction. Right. And I just keep coming back to, if this was a regular kid in a high crime neighborhood, disadvantaged neighborhood, on these facts, the jury interrupts and to say, hey, we're ready with our verdict now. Yeah, exactly. He's guilty.
Yeah. All right. Danny, good to see you. See you soon, I hope.
Thank you so much, Harry.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.